Hey, Mr. President.
Senator from Utah.
I rise today to honor one of our nation's greatest champions of limited government under the Constitution, Justice Antonin Scalia. He was a personal friend. I knew him very, very well. He set the standard for the kind of judge upon which liberty depends. The purpose of government, according to the Declaration of Independence and the Constitution, is to secure inalienable rights and the blessings of liberty. Liberty exists by design and, as Andrew Jackson put it, by eternal vigilance. America's founders were clear that liberty requires separated and limited government powers, including a particular role for unelected judges. Judges that seek to determine what the law is promote liberty. Judges that say what they think the law should be undermine it. Put simply, judges must interpret and apply the law impartially, that is, by setting aside their own opinions, preferences, or prejudices. When they interpret written law impartially, they discern what the original public meaning of the law is. When judges apply the law impartially, they pay no regard to the identity of the parties or the direct effect of their decision. Judges can neither make nor change the law they use to decide cases. Interpreting and applying the law impartially leaves the American people and their elected representatives in charge of the law. That is the kind of judge that liberty requires. That is the kind of judge Antonin Scalia was. When President Ronald Reagan first appointed Antonin Scalia to the U.S. Court of Appeals for the D.C. Circuit in 1982, the future justice said to those of us on the Judiciary Committee that if confirmed, the time for him to opine on the wisdom of the laws would be bygone, quote, bygone days, unquote. When he again came before the committee 4 years later as a Supreme Court nominee, he repeated that setting aside personal views is, quote, one of the primary qualifications for a judge, unquote. He described a, quote, good judge, unquote, as one who starts from the law itself and not, quote, where I would like to come out in a particular case, unquote. Justice Scalia stuck doggedly to this ideal of the good judge whose role in our system of government is limited to properly interpreting the law and impartially applying it to decide cases. Scalia's brilliance and wit were certainly impressive, but they were powerfully connected to this deeply considered and deliberately framed judicial philosophy rooted in the principles of the Constitution. Justice Scalia's approach requires self-restraint by judges. Judges, he often said, must take the law as they find it and apply it even when they do not like the results. In his own words, quote, if you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach, unquote. Liberty requires such judicial self-restraint, whether it is in vogue or not. As President Reagan put it when he administered the oath to Justice Scalia in September 1986, America's founders intended that the judiciary be independent and strong, but also confined within the boundaries of a written constitution and laws. No one believed that principle more deeply and insisted on implementing it more consistently than our Justice Scalia. His approach to the law was often called textualism, or in the constitutional context, originalism, an approach which is nothing more than determining what the lawmaker meant by what the lawmaker enacted as legal text. It leaves the lawmaking to the lawmakers rather than to the judge. The Senate unanimously confirmed Justice Scalia's nomination on September 17, 1986, the 199th anniversary of the Constitution's ratification. That was very appropriate because his approach gives the Constitution its real due, treating it as more than empty words on a page, but as words that already have meaning and substance. Justice Scalia knew that the Constitution cannot limit government's power if government actors, including judges, define the Constitution. Justice Scalia rejected judicial activism, what he called power judging, that treats the law as shape-shifting. For activists, the laws and the Constitution have no fixed meaning, but can rather be contorted and manipulated to fit the judge's own policy preferences. That is for activists. Such an approach puts the unelected judge, not the American people and their elected representatives, in the position of supreme lawmaker. Thomas Jefferson warned that if judges controlled the Constitution's meaning, it would be, quote, a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please, unquote. That is exactly what activist judges do, treating the law like clay that they can mold in their own image. Rather than reinterpreting the law in his own image, the good judge conforms his decisions to the fixed meaning of the law. By insisting that even judges must be the servants rather than the masters of the law, Justice Scalia was simply following the lead of America's founders and empowering the American people. Justice Scalia's approach to judging not only requires self-restraint by judges, it also demands rigor and accountability by legislators. The good judge takes seriously the language that legislators enact so that the people can hold accountable the legislators they elect. The famed senator and Supreme Court orator Daniel Webster once said that, quote, there are men in all ages who mean to govern well, but they mean to govern. They promise to be good masters, but they mean to be masters, unquote. Those who object to Justice Scalia's approach embrace the notion that judges rather than the people should be the masters of the law. Justice Scalia's impact has been enormous. A liberal legal commentator may have put it best in his review of Justice Scalia's book, A Matter of Interpretation, with these words, quote, we are all originalists now. That is to say, most judges and legal scholars who want to remain within the boundaries of respectable constitutional discourse agree that the original meaning of the Constitution and its amendment has some degree of pertinence to the question of what the Constitution means today, unquote. Justice Scalia brought the boundaries of respectable constitutional discourse more in line with the principles of liberty than they had been in a generation. For that, our liberty is more secure, and we should be deeply grateful. Justice Scalia was a person I knew well. I had meetings with him and others over at the Supreme Court. I knew him well before. He came to me in his confirmation pre-time, and we had a wonderful discussion. I'll never forget, this is a man that anybody who ever studied law would appreciate and care for. It was a terrible tragedy to lose him, to be honest with you. I think he was one of the all-time great Supreme Court justices and will go down in history as one who will be emulated by people who really know and understand what judges are all about. And I suspect that we can all learn from him. Because of Justice Scalia, this country is better off. Because of Justice Scalia, we have good examples of what a great judge is, should be, and was. Mr. President, I